Hello and a warm welcome to another special webinar that we have put together to talk about the impact of coronavirus or COVID-19. Thank you for taking the time to be with us today. In this webinar, we will explore the current situation on COVID-19 and its impact on deal making, the changing corporate governance regulatory regime in India, a litigator's perspective, and how data privacy laws will be applicable. COVID-19 continues to create an evolving list of challenges. India is among the 15 most affected economies. This webinar is our attempt to help the legal and finance teams to understand the current situation and some of its repercussions covering corporate, commercial dispute and data privacy issues. Besides its worrying effects on human life, COVID-19 is slowing down economy. Companies can take proactive steps to combat its negative effects. As frustrating as it is, we need to review our frameworks. My name is Rabindra Junjunwala, and I'm a partner in the Corporate M&A Practice Group at Khaitan and Company. I will be your moderator today. With me are a number of my colleagues, each an expert on their topic. And I will be introducing each of my other speakers before they address you. Some housekeeping points before I start. The duration of this webinar is about 1 hour, the scheduled time, of which the first 40 to 45 minutes will see 5 short presentations, mostly from our specialized teams. We will take questions from the audience in the last 15-20 minutes, which will provide you with an opportunity to raise issues of importance with our experts. To submit a question, simply use the facility provided in the webinar portal. We will endeavor to answer as many questions as we can in the allocated time. Please note, the slides and a recording of this webinar will be shared with you. Let us now begin with a very quick introduction to the topic in question. About 8 weeks ago, coronavirus wasn't a factor impacting the day-to-day decisions, but in a very short period, we have seen it unleash global chaos. Countries as a whole have gone into lockdown mode in an attempt to arrest the rapid spread of the disease. Major companies, entire nations have adjusted their growth forecast for the coming year on account of the blow dealt by the pandemic. It is evident that the impact of this pandemic will be felt for a long time. In such times of crisis, it is important to be cautious and take stock of the situation carefully before moving forward. If I may invite my first speaker, Samir Shah, who's a partner in the corporate commercial practice. Apart from time spent on transactions and commercial matters across sectors, he brings a specific sector knowledge, and his expertise is life sciences, healthcare, and retail. Taking a cue from health, he in fact believes that one needs to give special focus to mental well-being during this lockdown, maybe pick up a hobby. He tells me that he has started learning the guitar in the lockdown. Samir will be covering what has changed due to COVID-19 in the transactional world. This leverages on our firm-wide experience on how we have seen things change over the last 3-4 weeks and how we expect them to change in the coming months. I will, without further ado, hand it over to my colleague, Samir. Over to you, Samir Shah.
Thank you, Rabindra. And indeed, much happier times at the beginning of this year when I picked up on my New Year resolution to learn the guitar. Isn't looking as happy as it was then, very glum. What you have, ladies and gentlemen, on your screen are clear statements from the International Monetary Fund, the US Federal Reserve, and much closer to home, the Reserve Bank of India, all of whom are acknowledging that a recession is here or is imminent. And As with the ongoing travel advisories, all non-essential transactions are also taking a hit. So it is nobody's guess that deal activity will take a bit of a hit in the short term. Through the next few slides, we will of course discuss how ongoing transactions have had to alter course to meet the current requirements. Next slide, please. The first aspect of any deal, especially from a buyer's perspective, is due diligence. And as with everything else in a deal pipeline and a deal process, we've had to adjust and realign how diligence is conducted in these times. The first and foremost clear message that we are giving to all clients is that please assess whether everything else works. COVID is one issue. It can be one work stream with one leader securing inputs from all diligence work streams, but that should not become your sole point of focus. Because please remember, you decided to buy what you are looking to buy in happier times, and those times will eventually come back. Having said that, site visits will clearly become dearer and dearer, and it's important that people realize that such site visits may indeed have to be done as a part of either a condition precedent to closure, or depending on the integrity or importance of the site visit, potentially even after closing. What we are also seeing clients do is assess whether any drop in financial position is interim and caused only due to the outbreak, or is it because of a larger systemic issue or some chinks in the armor which have gotten exposed because of the current situation. Mind you, customers and suppliers continue to remain very critical cogs in the entire apparatus. And if there has been any interruption, whether on the customer side or on the supply side, it is important to assess the short term, medium term, and long term impact of that. Where that manifests itself into legal issues, are any payments due, any claims that may have been made and are outstanding. Manavendra will speak to force majeure when he gives the litigator's perspective, but please do remember there will be life after COVID, and therefore your diligence needs to focus on how robust is the business of the company when this current outbreak finishes. If there is any kind of a production disruption, please do assess whether it is a capacity issue or only an interim issue. Because, for instance, in certain industries, there are reporting obligations contingent on the levels of production. There could be export and import related tax obligations, and all of those need to be considered when looking at the impact of this outbreak. Insurance clearly is something which one cannot emphasize enough, and whether there is adequate coverage for ongoing business issues needs to be seen. All of this diligence will flip into how you structure a transaction, which we will discuss on the next slide. In terms of ongoing transactions, next slide, please. Yes. In terms of ongoing transactions, a lot of clients are looking at their contracts to see whether a material adverse effect or a material adverse change clause could become operative. Consistent advice to them has been, please do look at the clause standalone, but please resist the temptation to touch price. Indian businesses tend to be promoter controlled and owned, and any such move to touch price or other commercial terms may be seen in bad faith and affect the overall transactional relationship. As far as material adverse effect and material adverse change are concerned, it is advisable to look at the language and also check what were the carve-outs in terms of industry-wide issues as opposed to disproportionate issues that may be available. In most instances, our experience demonstrates that clients are willing to be patient because, as we mentioned when we would discuss diligence, they chose to buy the asset in happier times. and are therefore cognizant that the opportunity is not mired only in the short term. Having said that, your diligence will lead potentially to additional conditions precedent. For instance, any supplier claims or any customer claims for payment. You will look at your disclosures and your warranties that much more closely. A very quick word on warranty and indemnity insurance. We are currently in the midst of a deal where we are seeking insurance from the London market, and insurers have clarified that they will exclude any sort of a loss attributable to the COVID outbreak. So even the warranty and indemnity insurance market is very quickly adapting to the current requirements. Buyer delinquency is a question which a lot of sellers have asked us, linked again to the MAE and material adverse change clauses. Traditionally, India has been a market which very rarely sees escrows, bank guarantees, and payment-backed instruments, unless there is a specific deal factual issue. We are seeing the same practice continue, and sellers are, of course, pushing that deals be closed quickly. So having discussed diligence and having discussed structure, let's now move to closing, which is on the next slide. Two words have become synonymous with the current times, or two acronyms, if I may say. One is WFH and one is BAU. While it is definitely work from home, but specifically in Indian closings, it is nowhere close to business as usual. There is a significant amount of physical interface and personnel availability across the board, which is required to close an Indian transaction successfully. Start with payments, for instance. India has significant exchange control regulations. A lot of paperwork is needed, and a lot of coordination and hand-holding is required with the bankers in place. This requires physical documentation, original signature verification, at times withholding tax compliance. All of those things are getting, I would not say bottled up, but they are proving to take longer than they would otherwise take due to people working remotely. If you look at the requirement of obtaining a director's identification number for your director nominees, again, physical signatures, notarization, legalization requirements, all of these, whether in India or abroad, are being hit by the current business disruption. Any purchase consideration determinations or audits and adjustments. Once again, whenever there's a requirement of additional paperwork, finance teams are struggling to a certain extent. Mind you, governmental approvals is the one space where we are advising the most caution, because governmental departments have different priorities at this time. A transactional approval will not necessarily be at the forefront of their worries. As a result, thoughtful parties need to plan for appropriate long stop dates, which neither make valuations stale, nor do they make a closing timeline unrealistic. Be that as it may, a post-merger integration planning process, which otherwise sometimes may have commenced prior to closure, clearly is something people may not have bandwidth for, at least on a counterparty basis, before closure. This gives you a very brief introduction of what we are seeing in ongoing transactions. Back to you, Ravindra.
Thank you, Samir, very much for your practical insights. WFH, BAU, and adapting to situation are clearly the new buzzwords. Moving on to introduce our next expert and speaker. Aditya is a partner in the capital markets practice. He advises issuers, investors, as well as merchant banks on all forms of fundraising. While the spirit of corporate India is currently low because of the pandemic, our next speaker, and indeed us, believe that there is a ray of sunshine since the regulators are being proactive to amend laws to fit the current situation. In the next few minutes, Aditya will be touching upon some of the key regulatory changes announced by the Security Exchange Board of India and the Ministry of Corporate Affairs, and its impact on the governance and fundraising abilities of corporate India. He will hopefully conclude with some crystal ball gazing on the various asks from corporate India for future regulatory changes from these regulators. Aditya, over to you.
Thank you very much, Ravindra, and good afternoon, everyone. As entire corporate India gets used to the work from home regime, it is heartening to see that there is a silver lining of our regulators acting quickly and coming up with amendments to match our regulatory requirements. The trend followed by regulators is that most of their amendments target the near term of 3 months. But if the lockdown continues for a longer period of time, we are looking at a whole scale change to the way we all do business. With that said, I will dive straight into some of the key amendments which have been announced by the SEBI, which is the Securities Market Regulator, and the Ministry of Corporate Affairs. The first point I would like to deal with is that the MCA has come up with a very good relaxation that we do not need to hold physical board meetings any longer, and the time period between two meetings has been extended to 180 days. So earlier corporates, especially during this time, had to hold physical meetings of financial statement, board reports, prospectus issuances, as well as restructuring. All these can now be done through an audio-visual method. However, it is important to note that a teleconferencing is not permitted. It has to still be an EV method. Financial period for listed companies has also been increased. So listed companies which earlier had to do their quarterly and yearly financial results in the month of May now can do it by June 30th, 2020. Now, following the Peter Parker principle, with great powers comes great responsibilities, there is definitely an impact to these regulatory amendments. Some of the key impacts which we would see primarily in the listed space is that whenever a company's year end happens, there is a lot of unpublished price sensitive information which is available with the management. Earlier in this year, SEBI was taking a lot of investigations against corporates because a lot of information was leaked through WhatsApp and other forms by employees. So given that the data which management will be holding will be unpublished and price sensitive, it is very important to ensure that only select management get this data and it is adequately protected. Moving on, when we are doing video conferencing during this time, we should ensure that we used a reliable software provider so that this information is not recorded both at their end, nor can any participant of the meeting have the ability to record these meetings. Now, dealing with the extension of the financial statements, the corollary to that is that our trading windows also have to shut. So from April 1st, 2020, all listed companies will have to shut their trading window till 48 hours after their results have been announced. Now, the disadvantage of this is that promoters who are looking to capitalize on the low market prices to increase the shareholding will not be able to do market purchases. However, a workaround which we believe should be possible is that a preferential allotment can be made to the promoters as long as they do not have unpublished price sensitive information. Moving on to conducting shareholders meetings during this time, there is no specific relaxation which has been afforded by the MCA. So there are concepts of hybrid meetings in US and Canada wherein the meeting is televised and people vote remotely. Whilst we have remote voting, the former is not being announced by MCA. So the only way to pass shareholders meeting during this time would be through postal ballot. If you have physical shareholders, please remember that the notice would have to be printed and dispatched. Those would take time during this period, and it is very important for us to plan in advance so that the notices receive the right people on time. Next slide, please. On the next slide, I would like to deal with the impact of raising NCDs, both with respect to new issuances as well as existing NCDs. Now, on the new issuances part, SEBI has come up with a relaxation that if you have financials as of September 30th, 2019, you can issue your NCDs up to May 31st, 2020. This is a welcome relaxation because there are NBFCs who used to raising finances periodically, especially during this time to meet their various obligations and capital requirements. So having this would lessen the burden of the auditors and enable such issuers to tap the market efficiently. A point of caution on this is that given that the financial information included in the document is pretty dated and does not cover the COVID period, We would have to frame novel disclosures in your prospectus, as well as include risk factors, cautioning the investors that this period continues to remain uncertain and performance of the company can vary during this period. Another point to keep in mind is that a filing needs to be made with the ROC for a public issue of NCDs. We need to ensure that the ROC approval can be got on time, which requires liaising during these times. Now, with respect to the already listed NCDs, the RBI has given a moratorium period of around 180 days, a moratorium period for term loans. However, this moratorium period does not extend to NCDs as well. NCDs are private contract between investors and issuers. So if you require a moratorium period for your NCDs, it is very important that you get onto the table and negotiate that with your bondholders. Negotiating of a moratorium period is time consuming. You need to hold meetings of your bondholders. So it is important to seek advice from your legal advisors and start the process immediately, rather than wait for the repayment or interest payment obligation to come into place to start the process. We believe that negotiating financial covenants or a waiver from financial covenants should be an easier ask during these times. Also, it's important to realize a stock exchange approval is required prior to amending terms, so that has to be kept in mind in the timeline as well. Also, most of our NCD documentations do not have force majeure clauses. So if parties want to go or invoke such clauses, it will require some amount of thought to say that the current market situations because of the closure do not frustrate the contract. Next slide, please. Going into the previous slide, I would just like to cover some of the key amendments which have been given by the MCA and SEBI as well. One is the implementation of CARO has been extended. That will definitely reduce the burden of the auditors. Given the challenges around auditors doing on-site due diligence, we'll be looking at examination reports as well as audit reports having qualifications or matter of emphasis, restricting the procedures done by auditors during this period. Another important point is the waiver of your late filing fees. This is a welcome change made by the MCA. So from the period from April 1st to September 30th, if you do not make your filings, then you have an ability to, you will not be charged any penal interest for a delay in this. However, MCA has left this clarification with a saying that they would come up with circulars in the future, listing this out in detail, and the devil will continue to remain in the detail. SEBI has also jumped on the bandwagon and has come up with a dedicated ID for various issuances, wherein any SEBI-related filings can be directly emailed, and they have given their RTGS details in case any amounts need to be paid. So this would very easily facilitate making the necessary filings and avoid the delays in their online portals. Next slide, please. Now, to do some crystal ball gazing, we've had chats with corporates over the last few days, and we have come up with a list of asks from regulators, which has been sent to various regulators. I'll touch upon a few of these topics. First one is to review the pricing guidelines right now available for equity shares. As we all know, if you're doing a preferential allotment of equity shares in the listed space, the pricing cannot be below the 26-week volume weighted average price, or VWAP as we call it, or the 2-week VWAP, whichever is higher. So given that the market prices are considerably fallen for most corporates, to match it with the pricing which was there during the glory days would not be practical for deal making. So corporate India is definitely looking for relaxations on this area. The other point is on the threshold to increase promoter shareholding. Promoters would definitely like to shore up their shareholding during this time. Earlier, SEBI had allowed the peeping acquisition limit to be increased to 10%. The ask is that they try to do it this time as well. And the last point which I would like to deal with is mutual fund raising funds during this time. Redemption pressures on mutual funds continue to exist. That is because the trading windows of the stock exchanges continue to be open. They are thinking of having relaxed trading windows, but till that happens, initiative which SEBI can definitely consider is for mutual funds to borrow money from the market to meet the redemption pressures, rather than selling securities to meet redemption pressures. With that, I'll turn it back to you, Ravindra. Thank you very much.
Thank you, Aditya. Clearly, we see and expect several other government measures. And as a firm, we have also been writing to different authorities recommending some of these measures. If you are looking to receive regular updates from us on the important developments, feel free to write to us, and we'll very happily include you on our distribution list. Moving on to our next colleague, who's a member of our dispute resolution team. Manvendra will be dealing with the hot topic of force majeure in light of the situation that we find ourselves in. And in these strange times, everyone is trying to grapple and balance their legal contractual rights with the state directives and general commercial understanding. Amongst lawyers, probably it's the litigation lawyers who have felt the pitch hardest given the shutdowns. As an avid sportsman who spends most of his free time on the football turf or the cricket field, this lockdown has led our disputes team, Manvendra in particular, to consider unique situations and come up with innovative out-of-the-box solutions after assessing the needs. Manvendra will be covering the practical aspects of force majeure and the consideration for claiming the same. Over to you, Manvendra.
Thank you, Ravindra. Amongst us dispute resolution lawyers, there used to be a saying that the arbitration clause is the midnight clause. Seeing the current scenario and reading some of the force majeure clauses that we have been over the last 2 weeks, clearly it's a 11:50 p.m. clause, the way it has been worded in a lot of things. I think it would not be out of point to mention that historically force majeure events have not seen a lot of traction in India, notably epidemics. We have natural acts which have been construed in or written into a force majeure clauses, earthquakes, tsunamis, disruptions, etc., wars, but epidemics, quarantine, and the like are missing from a host of agreements. Coming specifically to force majeure, what really it signifies. Typically, a force majeure event is something which is beyond the control of the parties, extends for a certain duration, and for that particular duration, the parties are not in a position to honor their obligations in the contract. A force majeure clause cannot really be read into. If it is there in the contract, it forms part of the contract. You can't read one into it as per the judgments of the courts. The most important point for alleging force majeure is that the burden of proof lies on the person who is alleging force majeure or putting the other side to notice. In Indian law, no application of the Section 56 of Indian Contract Act, which deals with frustration, will come in light if there's a force majeure clause, as has been held by the Supreme Court in Energy Watchdog versus CERC 2017. This brings us to a very important question as to how do we deal with a force majeure situation or the instant situation in light of these judgments. A lot of hue and cry has been raised because of the 9.7.7 proclamation of force majeure under the procurement guidelines. Similarly, MNREGA also came up with a notification as to what can be construed as force majeure, and we have seen a lot of ports come up with their own notification of force majeure. To understand how force majeure really impacts one, you cannot blindly rely on any government proclamation, and there are certain essentials which have to be defined in the contract, which needs to be looked into. Let's look at them in the next slide, how really the practical aspects of invoking force majeure are. First and foremost, you have to examine the contract. Does your contract have a force majeure clause? If your contract has a force majeure clause, does the COVID-19 situation impede performance? And if they do impede performance, to what extent? Similarly, parties which are receiving a force majeure notice, please be mindful of the same considerations from your aspect. If there is the force majeure clause and there is an impact of COVID-19 on your business, the important consideration is to what extent you cannot perform your contractual obligation, what is the nature of disruption that has happened to the business. For example, if a contract for dealing with shipping goods or transport of shipping goods from port A to sector B is concerned, given that certain ports have issued force majeure proclamations, the subsequent part of the contract cannot be performed. In light thereof, you can raise a force majeure issue. However, please be mindful that the burden of proof still remains with the person who's raising, and for making sure you have to take mitigating steps. As a party, have you taken all steps necessary to avoid the non-performance of the instant contract? We have seen a very interesting case here where a particular EPC contractor was servicing a government project which comes under the essential items listed out. However, the government entity has decided not to invoke Force Majeure Essential Act and have shut down the project. Would that be construed in future as a non-loss of mitigation step or not is something which is very interesting. And typically, if you have seen any production sharing contracts of oil explorations, you would have noted that in such contracts, there are very express terms as to what kind of mitigating steps need to be taken by the operator in case of such events. Moving on, the most essential bit as on today is the proper communication of the force majeure event. Please remember that the communication today will form the basis of the cause of action in future. You must ensure that your communication addresses the issue, addresses the difficulty faced by you in performing it, and claim adequate relief. The contracts typically will have relief such as suspension of contracts, price adjustment clauses, or certain other specific relief addressed therein. To give an example, in the licensing contracts that are given out by the government to radio stations, the force majeure clause identifies epidemic and identifies quarantine as a force majeure event. However, it says that such clauses can be triggered only in cases of shutdown. Thus, if you have not shut down your company or you have not shut down completely the performance, how would you invoke force majeure in such a situation will depend entirely on the manner of communication and thus making sure that your relief claim is falling within the bracket of it. Some very important aspects which are being missed out in this instant scenario, and obviously given the chaos around projects, is the procedural requirements. If your notices have to be sent out within 7 days of the event, they have to be sent out within 7 days. Please be very mindful if there are specific procedural requirements. In some cases, there are requirements to report to authorities. Some cases, like diamond merchants are facing, wherein international entities, a PSU entity in Russia, has a particular clause where you must produce a certificate from the local authorities claiming it to be a force majeure. These kind of procedural requirements will need to be complied in some manner or addressed specifically in your communications today to make sure that you are dealing with it adequately. That said, you would also notice that this particular issue has led to a lot of potential insurance claims. It is very interesting when two parties claiming force majeure on each other may also have adequate insurance cover for both of them. So what happens in these situations will become questions which need to again be addressed specifically before you go in and you file your claim. Last but not the least, what happens in a situation where you don't have a force majeure? Well, Indian law identifies frustration or impossibility to perform in such situation. Again, Frustration is a concept where the performance of a contract subsequently becomes void. It is not exactly on the same principles as a force majeure, and hence you have to be very careful in identifying the nature of the event and what you are claiming under. Similarly, please be very mindful as to what is the repercussion of sending the force majeure notice. If there is a suspension of contract, will there be a price adjustment? Will there be additional costs? Does that force majeure notice mandatorily need to a termination within 30 days? And we do not have sight today if COVID will recede in 30 days. Similarly, if you are giving a notice under frustration, does it necessarily mean that you're looking to terminate the contract? These are the considerations that one needs to look into at this particular point of time, and especially in some of the sectors like real estate and infra, where there are multiple issues on a daily basis. Management of wind farms, management of projects, and what else can be done. These are some of the practical guidelines, and we'll be very happy to answer any specific questions that you may have later. Thank you, Rabindra.
Thank you, Manvendra, because you have very nicely summed up things, and I am guessing you will be quite busy during the Q&A session, so we will come back to you. Our next speaker is joining in from Calcutta. Shubhatin Chakravarti is a partner in the corporate and M&A practice, but specializes in data privacy. He's one amongst the few people in the country who's specializing in data privacy. In fact, he's in regular touch with the Ministry of Electronics and Information Technology, providing them with additional comments on our upcoming personal data protection law. Coming back to the webinar and the topic, at this hour, when the world is grappling with the pandemic, some of the countermeasures that are being taken by governments and organizations do encroach into zones of privacy and data protection. Some of these actions are legal, some others are just the practical need of the hour. They have hardly undergone any legal scrutiny. So in the next section, Shubhatin will take us through his piece on how organizations can tackle privacy and data protection issues, staying within the boundaries of law. He will also talk about privacy and data protection concerns during these times of work from home and how these can be handled. Shubhatin, over to you.
Thank you, Rabindra. And like you correctly said, our laws are really not tailored to attend to this situation. We have a patchwork of privacy related requirements under several laws, but none of them specially talk about a situation like what we are facing right now. And to make it worse, we do not have a special exemption as well to cater to the present requirements. So what I saw across the entire span of COVID-19 till now, basically, initially we had cases like an organization running to us saying that we had put up a thermal imaging camera at the gate, and there were some employees who raised an issue. And then we moved on to the work from home situation, where we received several calls where organizations are stating that we never thought that this kind of sensitive data of customers would have to be really handed over to our employees to work on them from home. So in the next few slides, what I'll do is I'll quickly take you through these phases. But before that, what is most critical is to understand the kind of data that we need to protect. The first is the largest bucket of confidential data, which may or may not have personal data, and that could be your client confidential data, your know-how, etc. And these are largely protected by contractual measures, technological means, and also intellectual property. The second bucket is personal data. Now, as far as present day Indian laws go, you need to have appropriate consent to handle personal data. The third bucket is sensitive personal data. The health information, etc., that you're collecting right now falls within this category. And for this, there are two pillars. A, of course, you have to have an adequate consent. And B, there are other measures also on the safekeeping, safeguarding of this information that you need to take care of. Next slide, please. So in the first phase of this pandemic, what we saw is organization did thermal scanning, temperature recording, obtaining of declarations of medical conditions, travel history, etc. And most of it still resides in the system. So what we need to be taking care of is the notice and consent aspect. To my mind, if you do a harmonious reading of several provisions of law, notice and consent is king. You should also have reasonable security practices and procedures as are set out in the Information Technology Act and the rules that are framed thereunder. There are certain restrictions in relation to disclosure and transfer. You need to adhere to them. You can only disclose it as per the stipulations of the law and transfer to any organization if the information provider is aware of it, and the transferee is also adhering to the similar requirements as the transferor under Indian laws. And finally, most importantly, I think data minimization or purging or deleting. Once this entire process or usage is over, the purpose is, of the usage is over, it's important to delete the information. Next slide, please. Now coming to the present day scenario where we have work from home, and organizations have handed over sensitive data to employees. Suddenly, we are having several audio video calls with our clients, with our own people. So for the first bucket of work from home and handing over sensitive data, I think the critical aspect here is to keep reminding employees of their obligations of non-disclosure and data protection and confidentiality. That's very important even at this hour. In relation to the audio video calls, just be careful that you are using credible service providers. You have gone through their privacy policy, the settings in relation to conference services. In recent times, you would have read that one of the most prominent service provider has been questioned, and it is possible that they are divulging some of the information to advertisers, marketers, etc. Coming to the next point, which is of usage of personal devices and internet connections. In this regard, I think what is important from a legal perspective is to see whether you have a bring your own device type policy. Okay, these come handy to ensure that you have a pocket already built in, or if there is none, then you should devise one quickly. From a technical perspective, we need to ensure that you have remote monitoring for any kind of unusual activity, and access speed bumps are there. And finally, because we are now almost getting comfortable with remote working from home, and there is hardly any physical document moving, we have a lot of weightage put now on e-contracting and usage of digital or electronic signatures. So whilst this is all fine, you need to just be careful that there are certain instruments which are outside the scope of electronic records. These are negotiable instruments, power of attorney, trust deeds, wills, and contracts for sale and transfer of immovable property. As far as electronic signatures are concerned, there are two buckets which have been sanctified under the Information Technology Act. Number one is the digital signature, and the second one is the electronic technique that is specified under second schedule of the IT Act, in short, which is basically the Aadhaar e-sign. So with that, I conclude my piece and happy to take any question. Back to you, Ravindra.
Thank you, Supratim. Ladies and gentlemen, we will now be moving to the Q&A section of this webinar. We have, in fact, already started receiving several questions. So I'm going to give myself 10 seconds, formulate my thoughts, and get started. But Supratim, do keep your phone on, because clearly a lot of people would be needing advice from a lot of things that you just mentioned. If I can start with you, Samir, do you really think transactions will continue to happen? And doesn't the stoppage of economic activity account for something? I'm clubbing a couple of questions which have come in. So if you can take these together. Over to you, Samir.
Well, that's an interesting question, Ravindra, because clearly in the short term there will be some hampering of deal activity, but in the medium to long term, as long as there is nothing wrong with the fundamentals of the asset or the fundamentals of the economy, things will bounce back. Even if you look at the experience from 2008, 2009, most transactional lawyers will concur that 2010, 11 was a really strong year. It wasn't a weak year by any stretch. So it may be a transient issue, but again, certain sectors will obviously take the hit harder than other sectors.
Thank you, Samir. And Aditya, what about um, how do you see what are the types of transactions which can take place during the trading window closure?
Thank you, Ravindra. Interesting question. So the insider trading regulations gives you a certain list of exceptions which can happen during the trading window closure. Some of these are off-market transactions, block deals. I believe transactions to fulfill any statutory obligations which you may have. If employees have their ESOPs, they can exercise it during this period. Pledges can be created because that will be the flavor of the season right now as security covers start falling. However, it has to be for a bona fide purpose. And any transaction for which there is a SEBI regulation in place, such as your preferential allotment, your buyback, delisting, open offer, and IPO, public issue of NCDs, as long as there's a SEBI regulation covering it, we believe that that should be fine during this period as well. Thanks.
Thank you, Aditya. And Manvendra, like we expected, there are some questions on force majeure clause. So get ready to answer them. First one, and just bear with me a moment, I see a number of questions coming in for force majeure. I'm going to, ladies and gentlemen, try and summarize and ask him joint a club of few questions. And while you're asking, please be very specific. It becomes slightly difficult to otherwise coordinate. Manvendra, first one, what can be the pitfalls of invoking a force majeure clause?
Thanks, Ravindra. Very interesting that people are actually looking to understand the pitfalls rather than rushing to it. Let's understand something very clearly. You have to see what are the reliefs under the contract if you invoke force majeure. Let's say suspension of contract is the first relief. The first question that arises is, do you have payment outstanding? Is there anything that is due to be paid? Is there any project, any amounts which are due? If there's a suspension, such amounts will not be paid out to you immediately, and you may potentially be looking at a litigation. Second, when you invoke force majeure, your reliefs are again restricted to that of a contract. I'll take you a live example of a matter. There is mobilization cost and there is demobilization cost, which is envisaged in the contract. However, there is no idle charges or standby cost envisaged in the project. If you are in a position to act, if the person is in a position to actually honor its commitment and they invoke force majeure, the timelines and the cost that they will suffer as a result thereof may not be proportional. Third, if there are situations wherein invoking of force majeure results in a termination after 30 days or 21 days if this event is not remedied, today we do not have sight if this COVID-19 issue will go in 21 days, and hence that may again be an issue. That said, these are times when I think parties are being reasonable with each other. Instead of rushing to invoke the force majeure immediately, it may be seen if a notice putting the other side to information about the issues being faced and raise the issues under the force majeure clause, which you otherwise would have raised as a formal notice, can be dealt with amicably, or at least a not so legal notice, putting him the other side to notice may be something to consider in this situation. Thanks, Abindra.
Moving on, and if I may, Manvendra, ask you to hold on there. What would be the minimum waiting period within which If the party is unable to perform obligations of the contract, then such party can invoke force majeure clause in the contract.
Okay, again, the most important thing herein would be the contract. If the contract specifies for 7 days from event or 15 days from event, one has to adhere to the same. However, this is also the place where there's a little leeway to maneuver, because it is the event from which the impossibility to perform the obligation arises that gives the trigger. Parties need to be very considerate if they can identify the trigger specifically, or at a particular juncture when they realize that this is the time from where the event from which the performance becomes an issue commences. You have to time yourself from that date onwards. There may be certain contracts which use the word reasonable time. In such case, in the past, we have looked at the notice clause in the contract to see what is the reasonable time being dealt with therein, or if there's some MAC clause in your contract dealing with material adverse change, what is the notice period prescribed therein. However, it has to be a reasonable period of time. It can't be at the party's choice.
Thank you, Manvendra and Supratim. Couple of questions which have come in on data protection. And again, I'm going to try and summarize them. So slightly longish, but bear with me. You spoke about providing notice to and obtaining consent from employees while obtaining health-related data. What all should be mentioned in the notice and the consent form? And can these consents be obtained electronically? Supratim.
Yeah, thanks, Ravindra. Firstly, yes, it can be obtained electronically. There is clear leeway in the Information Technology Act. As far as the elements are concerned, I think firstly, notice consent should be all clear and unambiguous. You need to clearly spell out the type of information that you're collecting, the purpose why you're collecting it and how it will be and why it will be used. The disclosure related details, how you intend to disclose, if at all, who could be the possible intended recipients of this, the reasonable security practices and procedures that you are following in order to protect such information. Apart from this, you also have to be careful that you give a right to the individual whose data it pertains to, the right to review and rectification. That's important. And you need to have a grievance officer, who would be responsible to attend to any grievance if such a data subject may have one. Thank you.
Samir, I would like to bring you back here, and our speakers have been giving a lot of insight, practical insights, as also doing some crystal ball gazing. Samir, what sectors do you think will bounce back first in terms of deal activity?
I guess a lot of lessons again can be taken from the earlier recessionary and financial crises. Services as a broad spectrum is probably a bunch of sectors which will bounce back first. So whether it's IT services, clearly, unless employees are required on site, they can work remotely. So there is an ability to service customer commitments. A lot of their customer contracts tend to be medium term to long term. So one would say that the business fundamentals of the IT sector will probably be fairly strong. Financial services, again, doesn't seem to be impacted that grossly. So again, something which will come back. Healthcare is currently king. I mean, they are the front line. They are the ones defending the general population. Although we have heard that certain healthcare fundraising opportunities have been put by the wayside, but some of that probably may just be on account of empathy to the management team, to not being able to give time and bandwidth to the fundraising exercise. So as a whole, is probably likely to bounce back the quickest. And manufacturing will probably take a little bit longer. That's the sense, Rabindra.
Thank you, Samir. And if you could start thinking about stamp duty and execution of contract, because I see some questions coming in, I'll come back to you. But before that, Aditya, if I may, you raised about preferential allotment and the pricing under the SEBI regulation. Will this be applicable to all types of investors?
Thank you, Rabindra. Interesting question. So the SEBI preferential allotment regulations gives a pricing formula as 26 weeks volume weighted average price or the 2-week volume weighted average price, whichever is higher. However, there are certain categories of investors which can avail of only the 2-week volume weighted average price. They are primarily qualified institutional buyers. So issuers looking to raise funds during this period, if they are doing the preferential allotment to less than 5 qualified institutional buyers such as mutual funds, FPI entities, insurance companies, etc., who have funds, then they can only look at the 2-week average price, and that will be more linked to what the market price is currently. Thank you.
Thank you, Aditya. And Manvendra, what you see would be the impact on EPC projects in particular?
So EPC definitely is a sector which has been hard hit, and there are a fair number of issues therein. If we look at the government projects, the ports, the projects which involve substantial construction activity, those which are not highlighted under the essential sectors are facing issues right from supply chain disruption, labor disruptions. They will see an increase in cost and a substantial change in timelines. While the increase in cost aspect is by itself not sufficient for force majeure under Indian law or common law for that matter, the EPC sectors have to be very careful about the way that they communicate with the subcontractors and the project managers communicate with the eventual persons who have filed the tenders. To cite an example, if your subcontractor has not invoked force majeure, but the project manager is invoking force majeure on a government project because they have a right to do so, the claims from the subcontractor onto the project manager will be something that they have to keep in mind. Similarly, the update which came in earlier yesterday, the transportations for non-essential items is being eased out now, and hence for parties for whom transportation was the biggest issue of raw materials can possibly want to hold their hands for 3 to 4 days and see what is the necessary impact before going forward and invoking force majeure. That said, it's a contractual situation. You have to speak with the regulator, the necessary ministries involved, and the persons, and possibly look if deferment and suspension are the way forward in this. Thanks, Rabindra.
And Shubhrutim, you mentioned about the computer emergency response team, the CERTIN, that they provided some tips in relation to work from home. Can you share just a few tips, perhaps?
Yeah, sure, Rabindra. I think most of these are very common, but the problem again is we need to continuously make our people understand and again appreciate these points. Some of these are, if you're using your home router, you need to ensure that you change the default password of the router, have strong and unique passwords, two-factor authentication. Do not share your work computers. If you do, then again, from an organizational perspective, what is very important is that you have a very strong policy of information technology. And few tips from my side on that is that ensure that you have these things written down very clearly, that you should not be using your office computer for personal purposes. If you are using it, ensure that you should not have an expectation of privacy, and all this information can be looked into by the organization itself, and most importantly, using any third-party service provider. Because why I'm emphasizing on this point is, in several employee investigations, we have observed that this provision is missing, and we hit a roadblock because in a strict reading of the information technology related rules today, you need this sign off from the employee if there is a sensitive data sitting there. And finally, of course, you should be careful on, no remember password option should be, ticked. and of course have, if you have remote sessions going on, they should be timed out after some time. Final point, which is happening very commonly nowadays, which CertIn has raised a red flag on, is that there are several phishing emails which are coming through, asking for donations, important updates, know who's impacted by COVID around you, so on and so forth. Just be very careful not to click on them. Over to you.
Thank you, Shrupatim. Manvendra, if I may ask you a couple of questions clubbed together. Can we invoke force majeure if our contract does not contain the clause? And linked to that, if there is indeed an obligation to take steps to mitigate the effects of force majeure clause, even if the force majeure clause does not stipulate this. So two questions in one.
I'll take the second part first. The mitigation obligation arises from the fact that force majeure envisages that a party will do everything in its capacity to perform its obligation. It does not necessarily need to be written into the clause, but that is one of the tests whenever a claim for force majeure is filed. Insurance practitioners will know that very well, because a lot of our insurance arbitrations precisely rotate around this particular issue. The second part of the question is with regards if there's no clause for force majeure. Again, in such cases, force majeure is a contractual obligation, as we discussed at the beginning. One may try and see if they can address it under frustration, or generally write to your counterparty and seek novation of the existing contract and certain relaxation that may be necessary. However, invoking force majeure, unless a regulator specifically provides for the same, may be a far stretch in this particular issue. You also have to be mindful that if you don't have force majeure clause, there will be no notification requirement, no timeline requirements for that particular site, and how you go about it will be a challenge. Thanks, Rabindra.
Samir, do you want to address the question about how we are paying stamp duty for commercial contracts before execution during the situation we are finding ourselves in, and anything linked to that? Over to you.
Sure. No, that's actually an ongoing operational difficulty, both execution of contracts and other stamp duty items such as share transfer forms, etc. And really, there is no one-size-fits-all solution. So there are certain states like Delhi, Karnataka, where you can still pay stamp duty online. So if you have signatories in those states, then it works. Buying stamp paper in the lockdown is out of the question, or for that matter, getting franking, or as we do in Maharashtra, we get what is called an ESBTR. Again, all of these involve a physical interface. So really, the only other way out is utilize whatever electronic payment options are available and try and see if you can manage signatories in those states. The other thing is exchange signature pages is something we've always done in transactional practice, but to the extent digital signatures are available with parties and those digital signatures are of the correct class and classification from the registrar, those can be used for execution. I saw a question around how to execute contracts, but particularly in transactional issues, just as a last point, especially states like Maharashtra, where the ad valorem stamp duties can be very high. We are of one client who basically paid minimal stamp duty based on whatever stamp paper was available, and they're willing to take the risk of getting this adjudicated upon and going to the collector afterwards, because there really is no way to pay full stamp duty at this point of time, even though they have the highest intentions to do so.
Thank you, Samir. We have received quite a few questions, and some of them are related to topics we have already covered in our previous webinars and will be covering in the coming days. Some on employment, HR issues, supply chain. I'm not going to take those because we are going to cover it separately. Feel free to stay in touch with us, drop us an email on the events ID if your question hasn't been taken up, we haven't been able to answer it clearly. We will also be sending you separately a feedback would be very kind if you could take some time out and give some comments, criticism, or even compliments. It would help us to improve the future webinars. We like to conduct a poll, so if we could take 30 seconds of your time, and if we could have the poll on the screen now. You just need to very quickly select one of the options. We'll keep this open for 30 seconds, and then we'll get back. Keep in mind, the firm has created its resource center, which provides updates on the COVID-19 in one place. They are hosted on our website. We would encourage you to check our webpage for latest information. If you want regular updates from us on important developments, please feel free to write to us, and we'll be happy to add you to our distribution list. We'll take the poll off now. Thank you very much for participating. We would be doing several other webinars. Unfortunately, we are out of time, and we would need to stop now. But thank you for the phenomenal participation. We've had a record number of attendees who have joined. Very kind of you to have logged on. We will look forward to being of service again at future Khaitan webinars. And we hope you found this session helpful. Apologies again if we were not able to take your question. We wish you good health. Thank you, speakers. Thank you, attendees, for joining us today. Please stay safe. Goodbye.